and welcome to a special Memorial Day edition of Bethea'S Byte Reloaded. I'm Ernest Bethea, the Last Outlaw, so good to have you all here today. And before we get started, I want to send a special shout out and salute to all those who have served and have given their lives to give us the freedoms that we enjoy today. Like the saying goes, all gave some gave all. And to those who gave all, I thank you and I salute you. God bless you all. Now let's get down to the business at hand. We've had a pretty wild week in true crime over the last week, and today the courtrooms are in recess due to the Memorial Day holiday. So I am privileged to bring this edition of Bethea'S Byte Reloaded to you on a Monday. So we are going to get started right now with a look back at the Menendez brothers case. Just because I'm taking a look back at that case doesn't mean by any means it's over. All right. As you see, the Menendez brothers case reflects a shifting culture across decades. Here's the way this has gone. The trials of Lyle and Eric Menendez came at a time of cultural obsession with courts, crime, and murder, when live televised trials captivated a national audience. Their resentencing and the now very real possibility of their freedom came at a time when true crime documentaries and docudramas have proliferated and brought renewed attention to the family. A judge made the Menendez brothers eligible for parole on last Tuesday when he reduced their sentences from life without parole to 50 years to life for the 1989 murder of their whole father, Jose Menendez, and mother, Kitty Menendez, in their Beverly Hills home. The state parole board will now determine whether they can be released. Their two trials bookended the O.J. Simpson trial, creating a mid-1990s phenomenon where courts subsumed daytime soap operas as riveting daytime television. People were not used to having cameras in the courtroom. For the first time, we were seeing the drama of justice in real time, said court TV anchor and host of Closing Arguments, Vinnie Politan. Everyone was watching cable, and everyone had that common experience. Today, there's a true crime bonanza happening, but it's splintered off into so many different places. The brothers came an immediate sensation with their 1990 arrest. They represented a pre-tech boom image of young wealthy men as portrayed in many 1980s movies. The tennis-playing, Princeton-bound prep. For many viewers, this image was confirmed by the spending spree they went on after the killings. Their case continued a fascination with the dark private lives of the young and wealthy that go back at least to the Leopold and Loeb murder case of the 1930s, but had been in the air in cases like the Billionaire Boys Club, a 1980s Ponzi scheme that spurred a murder. The first Menendez trial becomes compelling live TV. Their first trials in 1993 and 94 became a landmark for the then new Court TV, which aired it nearly in its entirety. Defense lawyers conceded that they had shot their parents. The jury and the public then had to consider whether the brothers' testimony about sexual and other abuse from their father was plausible, and should mean conviction on a lesser charge. The lasting image from the trial was Lyle Menendez crying on the stand as he described the abuse. At the time, there had been some public reckoning with the effects of sex abuse, but not nearly to the extent of today. The two juries, one for each brother, deadlocked, largely among gender lines. It reflected the broader cultural reaction, with women supporting a manslaughter conviction and men a guilty verdict for first-degree murder. Then we go to a tough-on crime era and a Menendez trial sequel. The trials came at a time when crime in the U.S. was at an all-time high. A tough on crime stance was a prerequisite for holding major political office, and a wave of legislation mandating harsher sentences has passed. That attitude appeared to prevail when, at their second trial, the brothers were both convicted of first-degree murder. As Associated Press trial reporter Linda Deutsch, who covered both trials along with Simpsons and countless others, wrote in 1996, this time the jury rejected the defense claim that the brothers murdered their parents after years of sexual abuse. Instead, it embraced the prosecution theory that the killings were planned and that the brothers were greedy, spoiled brats who murdered to get their parents' $14 million fortune. The second trial was not televised and got less attention. Vinnie Politan said there were no cameras, it was in the shadow of OJ, so it didn't have the same spark and pop as the first one. Such a less spark and pop that the Menendez brothers became a distant memory. They had become too well known to be forgotten, but for decades, the Menendez brothers faded into the background. Occasional stories emerged about the brothers losing their appeals, as did mugshots of them aging in prison. The public's memory of them was, yeah, I remember that trial, the guys with the sweaters in court, Vinnie Politan said. That would change in the era of true crime TV, podcasts, and streamers. As such, true crime goes big. The 2017 NBC drama series Law & Order True Crime, The Menendez Brothers, wasn't widely watched, but it still brought the case new attention. The next decade would prove more important. The 2023 Peacock docuseries Menendez and Menudo, Boys Betrayed, including a former member saying he was raped by Jose Menendez when he was 14. About the same time, the brothers submitted a letter that Eric wrote to his cousin about his father's abuse before the killings. The new true crime wave would continue to promote them, even if the portrayal wasn't always flattering. Monsters, the Lyle and Eric Menendez story, a drama created by Ryan Murphy on Netflix, made them beautiful but vain buffoons. And the actors were shown shirtless on provocative billboards. Javier Bardem as Jose Menendez brought Oscar-winning star power to the project that dropped in September of last year. That was followed a month later by a documentary on Netflix, The Menendez Brothers. Together, the shows had the public paying more attention to the case than it had since the trials. Almost simultaneously came a real-life turning point when then Los Angeles District Attorney George Gascon said he was reviewing new evidence in the case. The office of Gascon's successor, Nathan Hodgman, opposed the resentencing. Deputy District Attorney Habib Bailan constantly sought at hearings to make sure the carnage caused by the brothers wasn't forgotten, and repeatedly emphasized that they shotgunned brutally their parents to death. But the shifts in public perception and legal actions were already in motion. The judge's decision to reduce their charges came not with the drama of the televised trial, but in a short hearing in a courtroom that wouldn't allow cameras the broader public never saw. Despite his opposition, Hodgman was reflective in a statement after the resentencing. The case of the Menendez brothers has long been a window for the public to better understand the judicial system, he said. This case, like all cases, especially those that captivate the public, must be viewed with a critical eye. Our opposition and analysis ensured that the court received a complete and accurate record of the facts. Justice should never be swayed by spectacle. And to that To that point, I do agree. It should not be swayed by spectacle, but by the facts and the evidence in the case. Meanwhile, as far as the next parole hearing for the Menendez brothers, it has been pushed to August 21st or 22nd. We'll find out then whether the brothers will stay behind bars or will they be finally released. All right, now we get going. Next up on the docket, Holly Bobo's killer, which I'm gonna jump ahead a little bit later with Holly Bobo's killer in court asking for a new trial. But right now, I'm gonna take you to this next story. The mother abandoning their kids says in court, "I sacrificed my children." Straight out of Pontiac, Michigan. Detectives who testified against Kelly Bryant in court at a preliminary hearing used her own words against her, quoting, "I sacrificed my children." That evidence and more resulted in the judge ultimately binding Bryant over to trial on 3 counts of first-degree child abuse and 3 counts of welfare fraud. Bryant is the mother of 3 children found abandoned, living in mold, feces, and squalor this past February. The most notable observation was what appeared to be feces covering their clothing and their hair, Detective John Brish said. On February 14th, Oakland County Sheriff's detectives were horrified to find 3 children, ages 12, 13, and 15, living in squalor and abandoned in a Pontiac home for 4 to 5 years. "I'd never smell a home that smelled that bad without a decomposing body present," he said. On Friday, 3 months later, their mother was in court physically for the first time for a preliminary hearing. Prosecutors brought forth detectives who found her children, who interviewed Bryant herself. Brish said he'll never forget meeting Bryant at the police station 1 hour after they found her kids hiding in a bathtub full of feces. My God. Her appearance was the most surprising. Her hair was done. She was wearing what appeared to be clean. She had long fake nails, he said. Detectives say Bryant was always living within walking distance of the children she abandoned. She hadn't touched them or given them hygiene products for years. She would have food dropped off for them about once a week. She knew that her actions were selfish. That's her wording. And that it made her children sick. And that she ultimately sacrificed her children for her own purposes, Brish said. According to detectives, Bryant's children were found in soiled clothes, hunched over with toenails several inches long. The 2 youngest girls had started their menstrual cycles in the home and were only given pads once. Bryant admitted to telling the children to never leave or open the front door purposefully, instilling a deep fear in them. In those interviews, the court heard from all 3 victims of their irrational fear of strangers, pedophiles, and being blackmailed, said Kanika Ferenczi, the assistant prosecutor at the Oakland County Prosecutor's Office. Further evidence brought forth that Bryant would communicate mostly to the oldest boy through sporadic texts. He had his mother listed as world's greatest mom. She had her children listed as my oldest, kid 1, and kid 2. I would speak on the severity of the situation and concerns for the children and their path to recovery, and moving forward. And typically, her response would be, "Is there anything I can do to help myself?" Brish said. Detectives said that Bryant told them she lied to all of her family to keep her children hidden. She took the batteries out of the smoke detector in the home, so there was no risk of the fire department or any police officers coming by. The defense argues that after all the children were discovered in their care house interviews, the children did not seem to be suffering from severe mental harm. Those children were articulate. They were answering questions. They were asking for clarifications, said Cecilia Quirindrigo Bonso, Bryant's defense attorney. Ultimately, the judge did not agree. She sent Bryant to stand trial. "There is no question that this is an extraordinary case," said Judge Cynthia Thomas Walker. One critical piece of evidence not shown at the hearing was the children's interviews with Care House. The judge said that the interviews were overwhelming in terms of showing the mental and physical harm of the children. I'm totally speechless by everything I just read in that article. I'm speechless, yet at the same time, I am not surprised. Why? Because who would leave a teenager? No, I take that back. Who would leave two teenagers and a preteen in conditions like that and still call themselves a mother? Whenever I hear these child neglect and child abuse stories, I always say, that children do not have to worry about the monster hiding under the bed or hiding in the closet. They walk in wide open daylight. And what's worse, a lot of them are called mom and dad. In this case, mom. I hope and pray that when this case goes to trial, Kelly Bryant gets nailed with everything she's got coming to her. It's bad enough you leave your 3 kids behind, but to leave them behind in that condition, yeah. Whatever punishment that goes down, Kelly Bryant, you deserve every last bit of it. Let's see. Next up. I may have to turn on the trigger warning. An ex-wife charged with murder after a body was stuffed in the closet. Yeah, let me go ahead and pull up the trigger warning here. There we go. Let me flash it upon screen as well. There we go. That's what I was looking for. Now let me go ahead and get this story loaded up. Alright. Okay, so we're clear. Trigger warning is up. Here's the story coming out of Myrtle Beach, South Carolina. South Carolina woman is charged with murdering her ex-husband after she answered his door covered in blood. Police were dispatched to Frederick Van Stant's Myrtle Beach home on Friday for a report of a suspicious vehicle parked outside. When officers arrived, they saw a white Honda truck parked outside, but no lights on inside the home. In an incident report, detectives said that when they knocked on the door, it was answered by a woman covered in blood, later identified as Joanna Van Sant. Officers noted a large blood trail through the house and called Joanna outside while they went inside to search the property. Following the trail of blood to the back of the residence, they found Frederick's body locked inside a porch closet. Joanna's arrest warrant says Frederick was shot in the head, and she told officers when she answered the door that she had changed her clothes due to them being soaked in blood. Police have not offered any motive for the crime, and court records reviewed by Court TV reveal that Joanna and Frederick were previously married and divorced in 2021. So the story was short, but still, what could he have done for her to shoot him, for her to shoot her ex-husband and possibly shoot him at point blank range in the head? This is a case I'm gonna have to keep abreast of and bring you more details as they come. All right. Next on the docket, a woman charged in her son-in-law's murder describes the killer as so gentle. So gentle, huh? Provo, Utah. Recorded phone calls and interviews with police show Tracy Grist changing story after her son-in-law was shot and killed in her home. Matthew Rastelli was shot and killed on July 12, 2024, when he went to pick up his wife Catherine at her mother's house. Catherine's brother Kevin Ellis told police that he pulled the trigger in self-defense after Matthew threatened him with a knife. But detectives immediately took notice of some details they deemed suspicious and charged Ellis, Grist, and Catherine with Matthew's murder. New details about the investigation into the shooting and days after Matthew's death were revealed as Grist appeared in court for a preliminary hearing. Matthew's mother, Diane Rastelli, was the first witness to testify. She said that her son's relationship with Catherine had been a little rocky and described her daughter-in-law as having some episodes of being angry. Diane didn't learn that her son had been killed until July 13th, when Grist called and simply told her, "Man is dead." "I figured he was in a car accident," Diane told Judge Roger Griffin. Through news reports, Diane learned her son had been killed by Ellis and confronted by Grist in a phone call that she recorded and was played in court. On the phone, Grist repeatedly claimed that she was in shock and didn't want to talk about the experience, but said that she had attempted to offer life-saving treatment to Matthew after he was shot. Diane pushed Grist in the phone call, questioning why Ellis had access to a gun. In response, Grist described her son as so gentle and so kind and so sweet. In my mind, my son was only being protective and loving. From the call, Diane said, I think the family has a lot of explaining to do. This whole thing seems like a setup. Grist said, we would never ever plan to hurt someone. On cross-examination, Diane revealed that she had a falling out with Catherine in the weeks before her son's death. She said that while she usually took Matthew, Catherine, and their kids on an annual trip to Las Vegas, Diane informed them that she would not do so in 2024 due to Catherine's behavior. Diane said something was not right, and Catherine refused to speak to her. American Fork detective Joseph Norden also testified at Ellis's preliminary hearing, said that several suspicious things at the scene led officers to believe that this was more than a simple self-defense case. Among the irregularities was the fact that Matthew, who was left-handed, was found face down holding a knife in his right hand. 2 recorded interviews Grist did with police were entered into evidence at the hearing. In them, she told officers that they had been expecting Matthew to come to the house, but maintained she was startled to find him inside. Grist said Matthew was acting different and agitated, but said hello to her before leaving to speak to Catherine. Moments later, she said she heard gunshots. Something seems totally off about that story. I'm trying to put my finger on it, but I just can't at the moment. So what I'm gonna do is wait a little longer, get some more information, and come back before I can say anything else. Okay, next up. A man shoots son in the face while pistol whipping him, then opens fire on 2 more boys as they confront him. Here's our defendant, Chris Brown, and not the Chris Brown you're thinking of, ladies and gentlemen. Here's what we need to know. 36-year-old Chris Brown allegedly shot his 3 juvenile sons in Florida. That's according to the criminal affidavit. He shot one son by accident when the gun he was using to pistol whip the boy discharged and hit the boy's face. Brown then allegedly opened fire at his other 2 sons when they started to chase him while he retreated to his car. Now here's the full story. A Florida man is facing a lengthy list of charges after allegedly shooting his 3 sons over the last weekend. 36-year-old Chris Brown allegedly shot one of his sons by accident while pistol whipping the boy, and then opened fire on the other 2 when they went to confront him after he shot their brother. That's according to a copy of the criminal affidavit obtained by People magazine. He's now charged with 2 counts of attempted murder, 3 counts of aggravated assault with a deadly weapon, and 3 counts of aggravated battery causing great bodily harm. Brown faces an additional count as well for allegedly being a felon in possession of a gun. The affidavit says that the shooting occurred on May 18th while the three brothers were walking to a community pool from their home in Ruskin, a city located approximately 35 miles south of Tampa. The three boys, who are not being named because they are all juveniles, they told police they had been actively trying to avoid Brown on May 18th because he was causing issues at his residence. As they were walking to the pool, Brown pulled up and approached one of his sons with a pink and black semi-automatic in his right hand, the affidavit says. Brown then struck him in the left side of the face with a pistol, causing the firearm to discharge a single round which grazed his left jawline and striking his left earlobe. All that according to the affidavit. Then, as he retreated to the vehicle, the affidavit says that Brown discharged several rounds at his other two sons. Deputies from the Hillsborough County Sheriff's Office were able to obtain video surveillance of the incident as well as after canvassing the area, which showed Brown hitting one son and then opening fire as his sons are seen rushing toward their father as he enters the vehicle and discharged several rounds, according to the affidavit. The affidavit further alleges that Brown called one of his sons after shooting and said, "I tried to take your life, and you won't make it till Wednesday." That conversation was recorded by the son, who identified the caller making threats as Brown, according to the affidavit. Deputies arrested Brown later that same day, and his actions at that time led to additional charges, including resisting arrest, criminal mischief, and 2 counts of burglarizing an occupied dwelling, according to inmate records obtained by People. Brown was due back in court on May 22nd. He is not eligible for parole because he's a felon charged with attempted murder. Now, guys, I really don't know what to say here. What could possibly this goes in the same vein as what I said in the Kelly Bryant case earlier. You don't have to worry about the monsters hiding under the bed, kids. You don't have to worry about the monsters hiding in the closet. Those monsters walk the streets in broad open daylight. And to make it worse, sometimes those monsters, you call them mom and dad. Here are 3 right now in this story. One is being pistol whipped. The other 2 shot at. For what reason? Let me move onward because I believe I may have more monsters to deal with than just this one. Well, I've got another monster, but he doesn't have anything to do with kids. But what I will have to do is pull the trigger warning right back up again. Alright. Let me get myself prepared here, because this case is ugly. We're going to go inside the twisted case of a man who plotted to kill his romantic rival and then feed the body to pigs. Here's what you need to know. 57-year-old J.O. Sutherland pleaded guilty to using an interstate commerce facility in a murder for hire plot on May 14th and could spend a decade behind bars, according to a Justice Department press release. Sutherland hired a man to kill his romantic rival, the father of his then girlfriend's child, and then feed the man's body to pigs. In the weeks leading up to the planned murder, Sutherland hired a man to leave a dead Canada goose on his victim's mother's doorstep with a threatening message lodged in its beak. This man is sick. A New York man pleaded guilty to concocting an elaborate murder for hire plot against his romantic rival. One that included a plan to feed the victim's body to hogs and a deranged warning delivered via a dead goose on a doorstep. 57-year-old Jill Sutherland entered a guilty plea after being charged with using an interstate commerce facility in a murder for hire scheme. The U.S. Attorney's Office in the Northern District of New York wrote this in a May 14th press release. Sutherland attempted to arrange the murder of a man who was the father of a child with Sutherland's then girlfriend, according to the Justice Department. He agreed to forgive the death of the man who he hired to carry out the murder, the office wrote, and contacted a man he believed to be a Pennsylvania hog farmer to dispose of the victim's remains by feeding them to the animals. However, both the former and prospective hitmen were FBI informants, according to the Justice Department. Sutherland also hired a different man to put a dead Canada goose on the doorstep of his intended victim's mother and stuff a threatening message in the beak in the weeks before a planned murder, according to the press release. It was not the first time Sutherland victimized his romantic rival's mother. According to a criminal complaint obtained by Law and Crime, the 57-year-old man paid a man to set fire to her car to prevent her from testifying at a custody hearing. That man would also become an FBI informant in the case, according to the document. Speechless I am, and I'm only halfway through the article. The informant began recording his conversations with Sutherland about the planned killing. In December, the informant told Sutherland, "I have a van I can rent for like $250 from a nun. We can take him to the farm and let the hogs eat him," according to the complaint. Initially, Sutherland told his informant that his then girlfriend wanted to be involved in the hit, saying in one recording that she wanted him strapped to a chair so she could hit him with a baseball bat, according to the complaint. But he also noted that she would fold like an accordion if she were questioned, and later began to distance herself from the crime. He said in a later recording that he didn't want to know anything about the killing, but wanted photographic proof that the victim was dead, per the complaint. In another conversation, wanted photographic proof that the victim was dead, per the complaint. But in another conversation, Sutherland said he would probably be in Myrtle Beach the day of the planned hit, according to the document. Sutherland, his girlfriend, his girlfriend's child, and the informant all went to a bowling alley together on January 26th, according to the complaint, where the informant told Sutherland that he needed to be paid before carrying out the killing. The pair drove from the bowling alley to the home of one of Sutherland's relatives, where Sutherland gave the informant an Easy Pass transponder, a bottle of wild turkey bourbon for the hog farmer, and $1,450 cash. The agency arrested Sutherland the next day and charged him with using an interstate commerce facility in a murder for hire scheme. He pleaded guilty on May 14th, and his sentencing is scheduled for September 22nd. Sutherland faces up to 10 years in prison, a fine of $250,000, and a term of supervised release up to 3 years, according to the release. Just 10 years he's facing on a murder for hire? I'd say he's lucky. But to set it up to this is one of those cases you try to wrap your head around and I can't do it. I really, really can't do it. And another one is where the child is supposed to be caring for a sick parent, decides to end that parent's life. In this case, a nurse said she wanted peace for her hospitalized mom. Then she allegedly removed her breathing tube. A Miami nurse is facing manslaughter charges after deputies say she removed her hospitalized mother's breathing tube. 54-year-old Lonsette Sabrina Green, a licensed nurse practitioner with more than 20 years' experience, was arrested last week and faces a manslaughter charge after she allegedly removed her mother's breathing tube because she said she wanted her mother to die peacefully. This is all according to the Miami Herald, NBC Miami, and Law and Crime reports. Green's mother was hospitalized on May 5th due to shortness of breath. The local outlets reported this. Green then called her son and daughter to see their grandmother. When the children arrived at the hospital, Green allegedly said, "I'm pulling out," and removed the intubation tube, according to an arrest report. The Herald reported this as well. An alarm was activated and medical staff tried to intervene, but she passed away. When medical staff were in the middle of assisting Green's mother, she allegedly told them to stop because she wanted her mother to go in peace, according to the local outlets who cited the arrest report. That same evening, deputies went to Green's home to speak with her, the report said. Green then agreed to talk, but she said she wouldn't do it at her home, so deputies took her to the Miami-Dade Sheriff's Office headquarters, where they read her rights. Green appeared in court over the weekend, according to NBC Miami, where a judge ordered her to be held without bond at Turner Guilford Knight Correctional Center. All right. With that, I have but one question. And this is directed to Lonsette Sabrina Green. Who made you God Almighty. Who gave you the right to decide how and when your mother should die? Because the last time I checked, the one that held life and death in the palm of his hand is, in the words of my father, God bless his soul, is the one who sits high and looks low. I lost my mother 25 years ago. And I left her life in the hands of Almighty God and the doctors working on her. I would not dare to say I want my mother to pass away peacefully and then take away her breathing tube. I don't have that right. To be honest, that's first degree murder. That's first degree murder. You should be charged for it. You should be found guilty of it. And you should be put behind bars for it. Next. Cops say he strangled his daughter to death and the girlfriend witnessed something awful the day prior. What could it be? What could it be? The day before 5-year-old Zara Arnold died, her dad allegedly threatened to hurt the girl and choked her on FaceTime, according to reports. Oh my God. Just give me 1 second, guys. Okay, this is what I was talking about. Listen to this. Police say Zachary Arnold confessed to strangling his daughter Zara, age 5, on May 19th. Prior to her death, he allegedly sent his girlfriend a photo of Zara foaming at the mouth and choked her on FaceTime, according to reports from the Indie Star, WTHRT, and Wish. The girlfriend did not call 911 because she was afraid of Arnold. She called police. And where do we find the monsters, ladies and gentlemen? The Indianapolis Metropolitan Police Department, IMPD, says that Zachary Arnold confessed to murdering his 5-year-old daughter Zara Arnold on May 19th, according to court documents cited in the Indie Star, WTHR, and Wish. 41-year-old Arnold initially claimed that his daughter had fallen down the stairs when he called 911 to report she was not breathing that morning, according to the IMPD. He then changed his story while being questioned by detectives with the IMPD, allegedly telling them that he strangled his daughter for having an argument with his girlfriend. The detectives with the IMPD then spoke with Arnold's girlfriend, who confirmed that the two were fighting, and then allegedly said that he saw Zara being choked by her father. The Indy Star and News 8, citing court documents, report that Arnold sent his girlfriend photos of Zara foaming at the mouth, called her on FaceTime while choking the girl, and said to call 911 because he was going to hurt the little girl. She claims that she told him to stop, but thought he was just playing, according to court documents obtained by the Star and WTHR. At no point did the girlfriend contact authorities or tell anyone about the photo once she saw on FaceTime or the threat Arnold allegedly made about his daughter, according to the documents cited by WTHR and the Star. The girlfriend later told police that she did not call 911 because she was afraid of Arnold. Arnold had been previously charged with rape in 2020, but managed to get that charge dismissed in a plea deal with prosecutors, according to a sentencing order obtained by People magazine. He had also been charged with violating protective orders filed by Zara's mother on at least 3 occasions, according to the sentencing order. It shows that he entered a guilty plea to an invasion of privacy charge just days before his daughter's death. The judge in that case sentenced Arnold to 360 days in county jail, but then suspended all 360 days, allowing him to go home. That was on May 12th, a week before Zara's death. This past Wednesday, a spokesperson for the Marion County Coroner's Office told People magazine that Zara's cause of death was multiple blunt force injuries, and her manner of death was homicide. Meanwhile, the Marion County Prosecutor's Office was waiting for police to complete their investigation before filing charges against Arnold. He is now being held at the Adult Detention Center and is facing charges of murder and neglect of a dependent. The IMPD says more charges could be filed as the investigation is ongoing. The probable cause affidavit also notes that Arnold blames his actions on his girlfriend, telling detectives that she did this to him, and her actions are making him out to be a monster. No, Zachary. If you're on FaceTime telling your girlfriend to call 911 because you're going to hurt the little girl, you're the monster. Plain and simple. You are the monster. Now, before I end this, I have a public service announcement. Do I have that number? Yeah. Yeah, this is your public service announcement. This is a part of my. This is also part of the fact that summertime is here. We want you to be safe. We want you to be smart, especially around children. If you suspect child abuse, you are urged to call the National Child Abuse National. Let me try that again because I just got tongue tied. If you suspect child abuse, you are urged to call the Child Help National Child Abuse Hotline. The number is 1-800-4A-CHILD. 1-800-422-4453. Or go to www.childhelp.org. All calls are toll-free and confidential. The hotline is available 24/7 in more than 170 languages. No child should ever be abused, nor do they deserve to be. Call the Child Help National Child Abuse Hotline. That number again is 1 800 4 a child. 1 800 422 4453, or go to www.childhelp.org. Next on the docket, Bryan Kohberger's defense team is seeking a delay in the trial over the potential leaks that are being investigated. Bryan Kohberger's defense is requesting that his upcoming quadruple murder trial be delayed. He's scheduled to go on trial in August for the 2022 killing of 4 University of Idaho students: Madison Mogen, Xana Kernodle, Ethan Chapin, and Gailey Gonsalves, who were brutally stabbed to death in an on-campus rental home. Kohberger, who faces a potential death sentence if he's convicted of the murders, has maintained his innocence. In a motion filed this past week, the defense cites a recent Dateline NBC special, which aired on May 9th, as a reason for the delay. It argues that the episode violates a gag order that has been in place since 2023. The episode included video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The Dateline show repeatedly emphasizes the non-public nature of this information, stating that it was obtained from unnamed sources who are close to the investigation, the motion states. Moving forward with a capital trial in August will infringe upon Mr. Kohberger's constitutional rights, as counsel requires more time to review discovery, complete investigations, and prepare for trial. The motion comes less than a week before Judge Stephen Hippler said in a pretrial hearing that he is open to appointing a special prosecutor to investigate potential violations of the court's long-standing non-dissemination order. Judge Hippler ordered prosecutors and defense attorneys to provide a list of everyone who might have access to the previously unreported information about Kohberger's internet search history and other details that were featured in the Dateline episode. That's reported by the Associated Press. Kohberger's attorneys raised concerns about the special in an upcoming book on the case set for release in mid-July. Their filing states the blurb for the book suggests that the apparent Dateline leak was not the only violation of this court's non-dissemination order. A continuance is necessary to fully investigate the leaks and to mitigate the prejudicial effects of such inflammatory pre-trial publicity occurring so close to the current trial date, the filing says. Now, you guys know me. You know I'm all about getting justice, and I'm also about being on both sides, the victim and the defendant, getting fair treatment. And this leak is not helping anybody. So, I hope that whoever's leaking this information out to get all these get this Dateline special out gets busted. Something's got to be done to make sure Bryan Kohberger does indeed get a fair trial. Next up, courtroom erupts in applause as Jordan Henning's petition is denied. You know, in fact, before I go to the article, let's go to the courtroom as that happened.
Welcome back. We are following a domestic abuse hearing for military wife murder trial defendant Jordan Henning.
Now, Henning was found guilty of manslaughter in the shooting death of his wife, Ashley, and was sentenced to 20 years in prison. But at trial, Henning testified that he broke during a fight with Ashley after allegedly enduring years of abuse.
And that's important because Kentucky law allows victims of domestic violence to seek parole eligibility after serving half of their sentence. So the question for the judge, did Henning prove that he was a victim of abuse by Ashley? Let's go back into the courtroom now to hear what the judge's decision was.
The court has considered all the trial testimony. I went back and reviewed some of the testimony prior to the hearing. Specifically, reviewed all the video, interviews with specific segments of it. I've seen the entire video, as I think I say on the record, way too many times. I've been doing this for a little bit. Sometimes when you make these decisions, I don't get nervous because TVs are here, people out there, you're used to having to do this kind of job. I think you get nervous in this job when you want to make the right decision. You get nervous when it's an either or, real close. I think I got nervous yesterday, Colin. I think I'm still nervous. I'm not so sure I should have completely revoked the young man's probation yesterday. We'll see on that. How about that? I think I'm still nervous about that. I'm nervous about that. I'm not nervous about this. I'm not nervous about this one, Colin. I mean, it's clear to me. Mr. Henning is not a victim of domestic violence. Domestic violence, according to KRS 403.7202A, defines domestic violence and abuse as physical injury, serious physical injury, stalking, sexual abuse, strangulation, assault, or the infliction of fear of imminent physical injury, serious physical injury, sexual abuse, strangulation, or assault between family members or members of an unmarried couple. He must prove that there was domestic violence or abuse by preponderance of evidence. Now, again, that's lower than beyond a reasonable doubt. It's one of those things you call in civil cases more than 50%. I do not find that he has overcame that burden. I'm in agreement with the Commonwealth. I've got a video. These domestic violence cases, most time these cases come, they get to our Court of Appeals or our Supreme Court generally in family law cases here in our jurisdiction. People may know we have family law or family court judges that hear those cases. This court hears them some, so it is versed well enough in those cases and has reviewed all those cases. In most of those cases, well, maybe a little bit more nowadays, you kind of have some videos. I mean, we have video this night of an extended period of time that shows that actually Mr. Henning was the domestic violence aggressor. I did not see anything in that video. Like I said, I've reviewed that, I'm going to say at least a half a dozen times in either the majority of it or these specific portions. There was nothing, and I mean nothing, in that video from Ms. Henning that indicates to the court that there was any domestic violence on her part. Now, I do understand that that was a snippet in time. However, here's what the court is saying. The impact of that evidence, direct evidence of Mr. Henning's domestic violence against Ms. Henning, the court can easily draw an inference from that that on any of these other alleged occasions, you, sir, were the aggressor of domestic violence. Now, the evidentiary allowances for hearings like this, hearsay could come in and things of that nature. Just to be honest with you, I would have to believe you, sir, and only you, because there is no corroborating testimony in regards to you suffering physical violence. Your mother didn't corroborate. I have not heard anything in addition to today to corroborate. I did not hear any. Now, everybody has issues in any relationship, marriage or otherwise. Could there be yelling? Could there be screaming? Could there be, taking you something and throwing it up against the wall? Okay, that is not physical abuse or violence. That could go to the level of possibly infliction of this fear, imminent, but it must be imminent. Does he even believe that? I've got to believe you, sir. I don't believe you at all. I just want to. It's easy, folks. Easy. There's nobody here. There's no jury. I'm not doing this. I'm just saying, for the record, I don't believe. I would have to believe there's no other corroborating testimony. Okay, and without that corroborating testimony, you can't get over your burden of the preponderance of the evidence. Your counsel, Mr. Rigby, is correct that there are these subsequent findings, but I don't get there if I don't find that you were a victim of domestic violence. I do not find, by preponderance of the evidence, that any of the testimony, any of the documentation, any reasonable inferences that I can draw from that leads me to make a factual finding that you were a victim of domestic violence. Because of that, I will deny you the exemption because I do not believe you get to the second portion that find this correct nexus between the domestic violence and the crime, because I do not believe you were a victim of domestic violence. With that finding, I will deny the exemption. I'll be on a written order, and that will conclude the matters in this case with a corresponding judgment, so that any issues concerning the containing of this order with that judgment begins any appellate time for you to.
Michael, I just have to say, you heard the applause in the courtroom when he issued his finding. He is not finding him a victim of domestic violence. Two reasons. Number one, he didn't believe the defendant. And number two, there was no evidence to support what the defendant said was true.
No corroboration. And I had asked the question earlier of our guest if he thought that the entire record would be something the judge would consider. And he did. He said, I considered the entire record, including the videos.
Yes.
And in those videos, you, Mr. Henning, were the aggressor, were the abuser. At least that's the way it looked to the judge.
Yeah, absolutely. He said that more than once, that video showed he was the domestic violence aggressor.
Ow. The judge pulled absolutely no punches in that ruling. First off, my thanks to Michael Ayala and Judge Ashley Wilcott of Court TV for covering that. Jordan Henning, the judge, said flat out, and I quote once again, I do not believe you at all. He cited the video. He cited all the evidence that was submitted in the case, and it showed that it was Jordan Henning, not Ashley, but Jordan Henning, who was the aggressor and the domestic abuser. But the article goes on to say that a judge told Jordan Henning that he saw no evidence that he was a victim of domestic violence, as he rejected Henning's petition to reduce his prison sentence. Jordan was convicted of manslaughter in the death of his wife, Ashley Henning, who was shot to death in the couple's Kentucky home on Ashley's 37th birthday. Jordan had been charged with intentional murder, but a 12-person jury found him guilty of the lesser charge of manslaughter after he took the stand and testified that he broke during a fight with his wife after enduring years of abuse. Jordan appeared in court on last Thursday to petition Judge Larry Ashcroft to reduce his sentence based on a Kentucky law that allows victims of domestic violence to serve a lesser sentence when they kill their abusers. Jordan, who was sentenced to 20 years in prison, will be eligible for parole after serving 85% of his sentence. Had the judge approved of his petition, he would have been eligible after serving only 20% of this sentence, which would be only 4 years. Jordan testified at the hearing and detailed an incident in 2016 when they were still living in Colorado. Jordan said that he was trying to leave after an argument, and Ashley kicked him in the back, knocking him down the concrete stairs. J.D. Savant, Ashley's friend who testified at Jordan's trial, returned to the stand and said that while Ashley had pushed him down the steps, it was a reaction to his waving a gun and threatening to kill her ex-husband. Assistant Commonwealth Attorney Eric Carr, who led the prosecution at Jordan's trial, introduced printouts showing Jordan's account on a website for people with sexual fetishes. While the account was created 2 years before Jordan and Ashley were married, Carr pointed out that Jordan continued to update his profile, join groups, and post even after his marriage. Carr also pointed to many of Jordan's listed interests as evidence that there was no domestic abuse. The specific acts he claimed to be abusive by Ashley are things he lists on his website, Carr said. Some of the things he's claiming are abuse are not abuse. These are kinks that he's into. Judge Ashlock denied Jordan's petition to reduce the sentence, as you just saw, pointing to the video of the shooting itself as the most substantial evidence in the case. Mr. Henning was not the victim of domestic violence, he said. There was nothing, and I mean nothing, in that video from Ms. Henning that indicates to the court that there was any domestic violence on her part. The courtroom erupted in applause following Judge Ashlock's ruling, while Jordan showed no visible reaction to the news. So let me go ahead and do a little math here real quick, if I can pull my calculator up. Okay. So Jordan Henning is sentenced to 20 years behind bars. He has to serve at least 85% of his sentence before he's eligible for parole, which is 17 years. 17 years. I'm thinking at this point he's going to end up doing all 20. Next up, the judge is going to decide whether he'll accept a plea deal for a former Indiana sheriff's wife. Let's see what she is charged with. Search for accountability continues in Jefferson, Indiana, in the saga of a former Indiana sheriff who admitted to stealing millions of taxpayer dollars to fund his family's lavish lifestyle with deadly consequences. Jamie Knoll was sentenced to 15 years, 12 in prison, and 3 years on probation in October 2024. A career lawman who once appeared on A&E's 60 Days In, Knoll pleaded guilty to 27 charges of corruption, theft, official misconduct, obstruction of justice, and tax evasion in a plea agreement with prosecutors. Now, Knoll's estranged wife has signaled her desire to plead guilty. Misty Knoll appeared in a Clark County courtroom on May 21st for a hearing in which her lawyer withdrew her previous plea of not guilty. Addressing the same judge who oversaw her husband's case, Misty pleaded guilty to 10 felony charges of theft, tax evasion, in a plea agreement with prosecutors. So what's in the proposed plea deal? Special Prosecutor Rick Hertel said the plea agreement calls for Misty to spend 13 and a half months in custody and 4.5 years on probation. She would also be responsible for nearly $700,000 in restitution and the return of 9 cars to Utica Township Volunteer Firefighters Association and New Chapel EMS, the entities from which the Knowles are accused of stealing funds. Hertel told Special Judge Larry Medlock that victims supported Misty's proposed plea. Ultimately, the decision rests with Medlock, who said he would decide whether to accept the plea agreement before Misty's sentencing, which is scheduled for July 3rd. If the judge doesn't accept the proposal, we'll go back to the drawing board and start from scratch, the prosecutor told reporters after the hearing. Hertel said the judge could set a trial date, or the parties may return to the negotiating table. We'll look at the culpability throughout this entire case, and obviously we feel like Jamie Knoll was the most culpable. That doesn't mean Misty Knoll did not commit a crime, as evidenced today. She admitted that she committed a crime, but in the same breath, I think the hierarchy of culpability certainly rests with Jamie Knoll, Hertel said. The case against Jamie Knoll breaks down like this: as the sheriff of Clark County from 2015 to 2022, Jamie Knoll served as head of its emergency medical services for part of his tenure. Most of the charges to which Jamie pleaded guilty stem from his time as president and CEO of the Utica Township Volunteer Firefighters Association, which also does business as New Chapel Fire and EMS. An investigation revealed that Jamie used corporate cards and money laundering schemes for a variety of selfish purposes, from extravagances such as personal play, vacations, timeshares, cigars, luxury and vintage cars, custom suits, and used Rolex watches, to everyday expenses such as Amazon purchases, meals at Papa John's and McDonald's, property taxes, child support, home repairs, and even an $11,000 lawnmower. Jamie maintained his innocence at the start of the investigation, calling the allegations a political witch hunt. At his sentencing on October 14th of 2024, Jamie tearfully apologized to his victims, saying, "It's all my fault." More than 20 community members shared victim impact statements about the wide-ranging effects of Jamie's actions, including Tereva Hodges, the mayor of the rural county community of Charleston, 2 of Jamie's ex-employees who work for New Chapel EMS, Suzanne Davis, an EMT, Anitra Coatley Williams, Susanna Worrell, and Janice Marie Sweet. The victim impact statement by Jamie's former sister-in-law, Hope Knoll, brought him to tears. As executor of his dead brother's estate, Jamie was accused of pocketing money intended for his nieces and nephews. Hope called her former brother-in-law a sociopath before reading a letter from his niece that said, "Grandma, your mom, and Grandpa, your dad, would be very disappointed in you." Calling Jamie a political fascist, Special Judge Larry Medlock said he was signing off on the plea agreement with reluctance after expressing concern that an appeals court might overturn a stiffer sentence. "You've tarnished the badge and failed everyone in law enforcement," Medlock told Jamie. The cases against both Casey and Misty Knoll. Jamie's wife, Misty, and daughter, Casey, were both charged with felony tax evasion and theft. They are accused of stealing more than $700,000 from New Chapel EMS through their own purchases of jewelry, meals, and clothing. They initially pleaded not guilty to the charges. In February, Casey changed her plea to guilty and was sentenced to 9 months in prison, according to WDRB. Search warrants indicate Casey charged more than $100,000 to a credit card associated with Utica Township Volunteer Firefighters Association and New Chapel EMS on items including clothing, tanning, cosmetics, manicure and pedicure services, food, tickets, trips, alcohol, utilities, vaping products, gas, Netflix, and items from Amazon. At his sentencing, Jamie apologized to his wife and daughter, Casey, saying they did not share responsibility because he controlled his family's finances. But Judge Medlock said he didn't believe that to be true. Anything for money, right? Well, I'm gonna keep tabs on this and find out exactly what Chrissy Knowles' fate is, and I'll report it right back to you when I get the information. Next up for the Justice Serve file. He made a misogynistic remark to her at a party. Then she doused him with gasoline and lit him on fire. Alright, here's what you need to know. After a night of drinking, Corby Jean Walpole set her longtime friend Jake Loader on fire after he allegedly made a misogynistic comment to her. Loader suffered third-degree burns over half his body. The judge called Walpole's crime unprovoked and violent, and she was sentenced to 7.5 years in prison. Now, keep in mind, that's under Australian law. Let's dig in. An Australian woman has been sentenced to 7.5 years in prison for setting her friend on fire following a night of heavy partying, after he allegedly said a misogynistic comment to her. Corby Jean Walpole poured gasoline on Jake Loader, who was 23 at the time, and set him ablaze as they were drinking in her backyard on January 7th, 2024, according to the Australian Broadcasting Company. Walpole pleaded guilty to one charge of burning or maiming by using corrosive fluid, the outlet reported. On the day of the party, Walpole and Loader, who had been friends for 9 years, had been drinking for 12 hours. Walpole consumed between 23 and 35 drinks and cocaine during the party. Let's take a look at that from the Australian Broadcasting Company's 7 News.
A 24-year-old woman who doused her friend in petrol and set him alight on the Victorian border has been sentenced to 7 years jail. The victim was left with burns to more than 60% of his body. Phoebe Worthley was in court.
Good afternoon. Corby Walpole arrived at court today flanked by her family. They closed ranks around the 24-year-old electrician who wasn't keen to talk.
Ms Walpole, have you got anything to say to the family today?
Corby Walpole and Jake Loader were among friends celebrating a 21st birthday when an argument erupted over a supposedly misogynistic comment. It prompted the then 23-year-old to douse 5 litres of petrol over her school friend's head and set him alight. The court heard Walpole watched her friend of 9 years run around her yard on fire as his shirt melted to his body and he tried to remove it. Walpole pleaded guilty to 1 count of burn, maim, disfigure or disable a person by use of corrosive fluid. Today, the judge rejected Walpole's claims that she was provoked by Loader's comments. Judge Jennifer English told the court this is an act of serious and horrific violence that has left lifelong impacts, noting it's never easy sending a young woman to jail, particularly a young woman, but this has to be done as a deterrent. Walpole was sentenced to 7.5 years jail with a minimum 4.5. No emotions as she learned her fate and could be seen mouthing "it's going to be okay" to her inconsolable sister, while the victim's family could be heard cheering and clapping. Was justice served today in the courts?
Thank you, no comment. We're not allowed to comment.
Warpole will be almost 29 when she's eligible for parole.
Right now, though, let's turn back to Tennessee. We're talking about the murder case of Holly Bobo, convicted killer Zachary Adams, trying to get a new trial. Let's take a listen to some more of what his brother Dylan said in his police interview.
When they got there, who was driving? Zach was driving the truck. Who was sitting where in the truck?
I was thinking that Alton was back there too.
And we'll draw. This dot represents the front end of the truck. So the driver would be sitting here on the front seat passenger, and then you got a bench seat in the back. You're saying Zach was driving?
Yes, sir.
What was Jason?
He was
In the back?
Yes, sir. Yeah, right here.
You think?
Then Zach gets out from the door, gets her out, and also gets out. And they start going in the house.
Where did they pull up?
They pulled up to the carport.
To it or in it or beside it?
And to the carport,
If I remember right, the first time we talked, you told me something about it was parked out close to the carport. But now you're saying that this is the house and this is the carport and window. You're saying we're going to that. Does that dot represent the front you pulled straight? Got her out of the driver's side. Describe what was she doing, what did she look like, what was she wearing?
then long hair color, pink shirt, same shirt that, a little bit of that. Long hair.
Was her hair in any time, was it pulled back, down?
Down.
Was she fighting, kicking, screaming?
Or what was she going to say? They drove her into the house.
What did she say?
Like me.
Did she call Zach or Jason by name? You know, did it have anything behind her, or was she free? She had shoes on? What kind of shoes?
Like the shoes on.
Couldn't hear that. What she said, why me?
They didn't say nothing. They didn't say.
Where did they go? How did they get in there? You got a door open for him?
They came in the door.
Who was controlling her?
I'll be behind her.
They let her freestand. They weren't holding on.
No, they told them to the office ended up.
Okay. Add her up. Describe what's your name.
Whatever. I'm not here.
Okay. You got here in the house.
You said that Mr. Autry raped the victim 45 minutes, and then I believe you said Zach held you at gunpoint if you didn't rape the victim as well. You remember telling the TBI
I
that?
remember telling them that's all a lie.
And that Zach then raped. You remember telling that?
Yeah, I remember telling that, but...
And that this took place, I believe you said that it was an all-night abduction. You remember saying that?
I don't remember saying it. I'm sure they put their own words, own spin to it.
That they left at night and came back in the morning, 9:30, 10 a.m.
Yep.
All right. And that they said, or you said rather, it was Autry, you and Dylan, I'm sorry, you and Zach with Holly Bobo throughout the morning. You said that. At any point, did anybody say, now Dylan, there's a video of you at the ATM machine.
No. I've never seen that till today. I never knew it existed.
You possibly have the right to object to this. I'm not asking what you told your attorney. Did any attorney ever tell you, we have a video of your Silverado that morning at 11:12 a.m.?
No, sir.
At the BP?
No, sir.
You entered what's called an Alford plea in this case.
Yes, sir.
Can you reconcile for us why you entered an Alford plea? You're saying you had nothing to do with these folks.
Yes. Well, after watching my brother get 101 years, I mean, I didn't want to face that in the penitentiary, so I come to the conclusion, take an interest plea. That's what they come with me at. And I was looking ahead of time about getting out. I didn't want to spend the rest of my life in prison. I mean, I wasn't looking at this crime or looking at that. I was looking at if I get out.
Prior to your case, were you advised that you were going to testify against Zach and Jason Autry?
Yes.
Did you meet with the prosecutors?
They come see me one time when I was in O'Brien County.
You remember who the prosecutor was?
I don't remember.
You were told you were going to be a testifying witness in Zach's case.
Yes, sir.
Were you told by anyone, and we'll ask who, what your sentence was going to be if you did that?
No.
Were you told it would...
I was told nothing about that.
Okay. Were you in special education as a kid?
Yes, sir.
What were your disabilities?
Reading and comprehending. Reading something and comprehending what it says, Sometimes I might have to read it 2 or 3 times or get somebody to explain what it means to me.
what is to be believed? We have Zachary Adams' brother recanting his testimony. We have another defendant recanting testimony, and Zachary Adams is still left, which is why he's requesting a new trial because of all these recanting. Who's telling the truth and who is really responsible for Holly Bobo's murder? Another one of those cases to keep track of. And when we get all the information, you get it right here, Bethea'S Byte Reloaded. Next up, this one is crazy. You remember the Sherry Papini case? The woman who claimed she was abducted, only to find out that it wasn't true? Well, she went to court, says that the kidnapping is not a hoax, and is pointing the finger out of all people, her ex-husband. The California mom who faked her own kidnapping has broken her silence. Sherry Papini admits she kept some secrets about her 2016 disappearance, but she's doubling down on her insistence that she was tortured during the 3 weeks she was away. Papini, who initially told authorities that she was abducted by 2 Hispanic women, is now saying her ex-boyfriend snatched her while she was jogging near her home in Redding, California. The 42-year-old Papini spoke out in a 4-part docuseries, Sherry Papini, Caught in a Lie, which premieres today, May 26th, on Investigation Discovery. On November 2nd, 2016, Papini's apparent disappearance prompted a frantic search that ended on Thanksgiving Day when she was located along a highway with a chain around her waist. She was bruised, emaciated, and branded with the word Exodus on her shoulder. She told the FBI that 2 Hispanic women grabbed her at gunpoint and tortured her for the next 3 weeks. In March 2022, Papini admitted to detectives that she was staying 600 miles away at the Orange County home of her ex-boyfriend, James Reyes. Her wounds, police said, were self-inflicted. Papini was promptly arrested and admitted to lying. Papini's husband, Keith Papini, filed for divorce in April 2022, the month following her arrest. He was granted sole custody of their 2 children. In September 2022, she was sentenced to 18 months in federal prison. Fast forward to today, Papini is once again switching up her story, pointing the finger at Reyes, despite previously admitting that she stayed in her ex-boyfriend's home voluntarily. In the docuseries, she claims she didn't name her abductor out of fear. Reyes, who appears in the docuseries, denies it. Now I have a vague recollection of this case, but I do remember the fact that she claimed she was abducted, only to find out that she wasn't. So, as far as I'm concerned, Sherry Papini, I'm going to say the same thing to you as the judge said to Jordan Henning. I do not believe you at all. That's all I got to say about that. Finally, another gruesome case. A teacher arrested after a 4-year-old Alabama girl ingested ethanol on her watch. Here's your defendant, 56-year-old Tracy Walker. A teacher was arrested in Alabama after a 4-year-old student in her care was taken to a local hospital with a blood alcohol concentration at a dangerous level of nearly 0.29. 56-year-old Tracy Walker was taken into police custody on Wednesday, May 21st. The former special education teacher is charged with aggravated child abuse, according to the Mobile County Metro Jail records obtained by Fox 10 News. At a hearing on Friday, May 23rd, the teacher's bond was set at $25,000 by Mobile County District Judge Joanna Bucci. Judge Bucci additionally ordered Walker to submit to a drug and alcohol test as a condition of the bond, per WTVY News 4. The child, a student at Collins Rose Elementary School in Mobile, Alabama, was brought to the hospital by her parents on April 28th, where doctors found high ethanol content in her bloodstream. According to the school website, Walker works as a special education teacher and has been placed on administrative leave, per WTVY. Defense lawyer Derek Williams reiterated that Walker has no prior criminal history during the bond hearing, according to the station. He referred to Walker as an achieved 10-year employee with bachelor's and master's degrees from the University of South Alabama. The case was initially investigated by the Pritchard Police Department, but has since been transferred to the Montgomery County Sheriff's Office as of May 6th, per Fox 10. People magazine reached out to the Montgomery County Sheriff's Office for comment, but did not immediately hear back. During an interview conducted by MCSO detectives with the 4-year-old child, the child reported that her teacher had given her a drink that made her feel sick. That was confirmed by MCSO, the CBS 42. The child's father told the station, "To us, that's a step towards justice being served. I'm still trying to process it." A spokesperson for the Mobile County Public School System released a statement following the arrest saying, "We take all allegations seriously. The teacher was placed on administrative leave when this allegation was first made." The statement concluded, "We have been cooperating with law enforcement on the investigation, and we will continue working with them." People reached out to Walker's defense for comment, but also did not immediately hear back. It's crazy, I tell you. You have these people in charge of taking care of your child and educating them. And in this case, this one is arrested for a child getting ethanol in her system. My God, what are we coming to when we can't even take care of our kids? All right. So I'm done with this past week's docket. Now let me get down to the issue as to why I'm doing this particular edition. If you know me, for the last few years, I do this annual warning about summertime, warmer weather, kids and pets in hot cars, and vehicular heat stroke. But for those who don't know about it, we are going to take you to get you into this right now. All right. The dangers of hot cars, even on mild days. The temperature inside a parked car can rise rapidly, reaching dangerous levels within minutes. I'm going to show you guys a chart on that in just a moment. In fact, let me go ahead and let you follow along here. Children and pets are especially vulnerable because their bodies heat up 3 to 5 times faster than they do adults. Cracking the window open, just cracking it open, does not significantly slow the temperature increase. Here's a couple stats. Since 1998, over 900 children have died in hot cars in the United States, with an average of 38 deaths a year. Heat stroke can occur when the body temperature reaches 104 degrees, and death can happen at 107. Pets can suffer brain damage or death within 15 minutes of being in a hot car. Before I go to these prevention tips, let me give you some stats to deal with and this chart. Last year, in 2024, there were 39 child deaths due to pediatric vehicular heat stroke. That's here in the United States. Just 39. In my opinion, it's 39 too many. Since 98, a total of 1,013 children have died from being left in hot cars. These tragedies are preventable, and spreading awareness is crucial in saving lives. Let's take a look at this. Now, I'm only highlighting the outside temperatures here. You have an outside temperature of 80 degrees. A child inside the temperature inside of a hot car after 10 minutes, it's 99. After a half hour, 114. After an hour, 123. Now that's 80 degrees outside. I'll jump up a bit and go to 90 degrees. Now think about it. 90 degrees. Let's not factor in the humidity. Let's not factor in any kind of heat index or anything of that sort. It's just 90 degrees air temperature outside. Inside a hot car. Inside a car, 10 minutes. The temperature is 109. 124 after a half hour. 133 after an hour. Keep in mind, a child suffers heat stroke at 104. After just 10 minutes. And that's under 85 degrees. And death can happen at 107. You see, as you look at this chart, these temperatures can become life-threatening in a very short time, especially for children and pets. And like I mentioned earlier, just cracking the window does not significantly slow the heat buildup. So here's some prevention tips before I get out of here. Look before you lock. You always want to check the back seat before leaving your car. Keep reminders. Place a stuffed animal in the front seat or set phone alerts. We're always on our phones anyway, so why not add that reminder? Now, let's keep the kids from climbing inside unattended vehicles by locking your car. And for those of us outside, if we see a child or pet in distress inside a hot car, it's up to us to call 911 immediately and get help. We're not looking for kids or pets to die this summer because of our neglect. Now, guys, today, for 3 years running, I've given this warning. Every summer, I have the unfortunate task of reporting on yet another senseless hot car death. And every time the excuses remain the same, especially my favorite. I forgot he or she was in the car. Now let me hit you on some reality. A child's life is not an afterthought. A pet's well-being is not a mistake to be realized too late. You saw the chart. Temperatures inside a vehicle rise within minutes. And once heat stroke sets in, there is no undo button. So I plead with you, this Memorial Day weekend and every day, look before you lock, remember who's in the car, and never ever let "I forgot" be the reason for tragedy. If you see a child or pet in distress inside a hot car, call 911 immediately. It's not just awareness, but it's action that saves lives. Can't express that enough. So that's going to do it for me on this Memorial Day edition of Bethea'S Byte Reloaded. I thank you so much for watching. I hope you got a little something out of it. If you liked everything you saw, please, I ask you to like, share, subscribe, drop me a comment. This is a free way to support the channel. If you want to support me financially, that's great too. You can hit me at PayPal, PayPal.me/EKB316, or by Cash App at $EKB316. Nothing is obligated, but it's always appreciated. You can always hit me up all over social media. Facebook at Bethea'S Byte Reloaded. X in all caps at EKB316. Right here on YouTube at Bethea'S Byte Reloaded. On Instagram at EKB316 in all lowercase. At King of Hearts 316 2021 on TikTok. And you can email me. My address is kingofhearts316_09 at outlook.com. Alright, here we go. This is your home for true crime news without the drama, where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, justice is served. I promise you, no gimmicks, no drama, no BS. This, ladies and gentlemen, is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the Last Outlaw. Thank you so much for joining me here, and let's do this again, same time, same place. Until next time, you all know what to do. Bite this. Thanks for watching. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.